Hello and welcome to our Q&A today called You Decide Who Decides, a Q&A about making an enduring power of attorney. So welcome to everyone as you're joining us here today. My name is Brett Osmond. I am the editor of Compass. Compass.info is a project of Elder Abuse Action Australia and is our national information hub on combating elder abuse, raising awareness about abuse in all its forms, and helping people find information to respond and reduce the incidence of risk in their lives. I am delighted to be joined today by Tara Simpson. Tara, hello, and thank you very much for joining us today. Tara is part of the internal legal service supporting older people who receive Commonwealth assistance as part of their aged care service. And she is from Aged Care Advocacy Service in South Australia. So today's session is all about South Australia. So we're going to get very specific, and it is also about answering your questions. So we're going to use the chat today. Please type your questions in the chat and we'll be sure to get them to you, get answers back to you. Now, I am joining you here today from Sydney on Gadigal land, and I welcome elders past and present, along with welcoming you all to what should be a really interesting conversation about enduring powers of attorney. So, Tara, I'd like to start our conversation by asking you a really simple question, which is, what is an enduring power of attorney for financial decisions?
So, an enduring power of attorney is a legal document that any adult can prepare and execute, appointing one or more adults to make financial decisions on their behalf, normally in circumstances when they're unable to make decisions for themselves.
Right. Thank you. And it's, probably worth noting, even though we are focusing on South Australia, that an enduring power of attorney has different legal scope depending on which state and territory in Australia you live. In some states, it is purely for financial matters and legal matters. And in other states, it does take in health and lifestyle. We'll try today just to focus on financial matters, but it's worth noting, because we are talking about South Australia, that in the Northern Territory, it is called an advance personal plan, and you don't appoint attorneys, you appoint decision makers. Now, all of this information and more is available on the Compass website. That's compass.info, and we have a comprehensive section on enduring powers of attorney. Now, we've got a question straight up from Charlotte that I'd like to put to you, Tara. Charlotte says, I have a client who cannot physically sign due to Parkinson's, but still has decision-making capacity. How can they go about doing this for an advanced care directive and an enduring power of attorney? Legal Services Commission couldn't provide an option. So what's available for Charlotte's client?
So let's take this into the different stages that the question provides. If it can be satisfied that the person has legal capacity, and what that means is that they understand what an enduring power of attorney and an advanced care directive and wish to prepare and execute one, their inability to physically sign a document is not necessarily the end of the matter. There are some options, and you need to source legal practitioners who is knowledgeable and experienced in this space so that they can support you. And what I'm referring to is that the options are, it is possible for a person, for example, with a disability, but with legal capacity, to place a mark. So it doesn't have to be a full signature document. That's one option. The other option, that it is also possible to sign through a third party. So
Okay.
you instruct a third party to sign on your behalf. Normally, everybody's present at the time, because it is then up to the authorized witness to be satisfied that entire execution process is appropriate and lawful.
Mm-hmm.
So it's really an important question, and thank you for asking that question, because
It
people
is.
with disability shouldn't be hampered from preparing these type of documents.
Yeah, absolutely. Thank you, Charlotte, for asking that question. I guess because Charlotte has put that question to us, it's probably a good opportunity to talk about capacity, because when you talk about an enduring power of attorney, you often have you're thinking about capacity. You obviously have to make this document before you lose capacity. And as you've just sort of highlighted, capacity is the ability to make a decision. And there are a few steps, aren't there, in that process, which is that you understand the decision that's being put to you, that you can weigh up alternatives, and that you can respond or communicate an answer. And that doesn't have to be in writing, does it? Or verbally. It can be, it can be adjusted to suit. So who decides if you have capacity or not?
So technically, capacity is a legal question that
Mhm.
is to be determined in the legal jurisdiction. What happens in practice a lot of the time is that the evidence that is relied upon is provided by the medical profession. So with older people, for example, there'll be a geriatrician report or a neuropsychiatrist report that would form an assessment. Then that is then used to assist and determine whether the person that's before you has the capacity or not. But the key element is that capacity is decision specific.
Right.
So I may receive a report to say Tara's got dementia. That doesn't necessarily translate to me not ever able to make a decision about all matters.
Yes.
Might be certain aspects or certain decisions I am well capable of making a decision on despite the diagnosis of dementia. So it is decision specific. In the enduring power of attorney jurisdiction, what needs to be determined is whether the person can understand what an enduring power of attorney is, what its intent and what its purpose, what are the choices available to me, weighing up the consequences of each of those choices, and then communicating what my decision is. So there are the sort of the steps that needs to be undertaken so that capacity could be met.
Right. And I mean, you highlight a really good point, which is, say somebody has received a diagnosis of dementia or another cognitive condition, um, that doesn't automatically mean you don't have the ability to make decisions. Dementia and many other conditions are progressive. And so you may have capacity to make all sorts of decisions for a very long time, but then might lose the ability to make very complicated financial decisions, but be perfectly able to make decisions about what you want to wear, what you want to eat, and other decisions. So there's a great article on Compass called Dementia and the Misconceptions around decision making, which I do highly recommend. Now, if you do receive some form of, a diagnosis that you've lost capacity, is it a permanent diagnosis, or can you lose capacity and then regain it?
Oh,
Uh,
absolutely, absolutely.
yeah,
And can I make this particular point? One of the misunderstanding in the community at large is that capacity is not a binary concept. It's not that you have it and then suddenly you don't.
right.
Actually, capacity exists on a spectrum for all of us.
Yes.
Then that's why the point of it being a decision specific test is quite critical. The other aspect of capacity is that it fluctuates. It can come and go. I might be in a car accident in a coma for 6 months, then I wake up
Yeah.
and
Yeah.
and I'm fine. And so people shouldn't be labeled too quickly because
Yep.
of an injury, because of a diagnosis. It really depends on how that person travels.
Yeah. Yeah. Now, I will, throughout today's conversation, be highlighting some resources that you can access on compass.info. And there is a great story and short video called Having Capacity, which I do encourage people to access. Now, we've got a question here from Sue. In South Australia, is it financially only? So, yes, when we're talking about an enduring power of attorney in South Australia, is it only about financial matters, or does it?
Yes.
Yes, it is.
It's
Yes.
only about financial and legal, and the question is really important to note, because in South Australia there is another document that an adult can prepare, and that's the Advanced Care Directive. And
Right.
the Advanced Care Directive is what I used to call the sister or the brother of the enduring power of attorney, whichever way you would
Yes.
lead. But it's where you appoint one or more individuals to make accommodation, health, and lifestyle decisions on your behalf.
Right. Yeah. So, good question, Sue. In Australia, enduring powers of attorney are not harmonised. So, we do find, say, in New South Wales, it's only for financial matters. In Queensland, it's health and lifestyle, as well as financial matters. I think the country is sort of almost split 50-50. So, you can also, it's another reason why it's very important to know what applies in your state. And there is a section on Compass specifically for South Australia, which you can access as well. Now, we've got another question from Charlotte. What do you do if you cannot get an appointment with a geriatrician and a GP won't sign a document, even though they don't believe the individual has capacity? Very advanced dementia in this case.
It's very, very challenging. It really depends on what it is you're trying to achieve. What
Yeah.
is the outcome that you're trying to achieve, that your pathways might then reveal itself. If we think about what this documents and how it functions on the ground, it is the third party that you're presenting it to
Hmm.
that you need to kind of convince, I suppose, on a practical basis. So, for example, if I've been appointed an enduring power of attorney by you, Brett,
Yeah.
or you, sorry, let's start again. If I wish to prepare and execute an enduring power of attorney, but I may have a medical condition that may put into question my capacity to execute and populate an enduring power of attorney, you've got a couple of options. You either try and execute one before an authorized witness, because the authorized witness also need to be satisfied that you understand that document and
Yeah.
have relevant capacity. Now, if one signs it, technically the document's acceptable.
Yeah.
Proven practice suggests that if there are some medical conditions at play that may challenge the validity or the legal enforceability of an enduring power of attorney, then you would want to get a medical report. But if you're getting challenged by getting that, there's no easy answers to that.
Right.
It's just the reality of life. Because if you then complete one and you go to the bank and say, hey, I'm the attorney of Brett, and the bank says, yeah, I'm not satisfied, I need you to get a report, you're sort of
Yes.
stuck by the requirements of the third party that needs to
Yes.
be convinced it's a legal document.
Yeah. Now, in South Australia, when you prepare an enduring power of attorney, do you have to register it?
There is no registration in South Australia. There's a kind of a misunderstanding as well. What people can do is lodge an
Mhm.
enduring power of attorney with land services when there is a transaction involving land, but
Right.
that's not equivalent to registering,
No.
and really should only occur when you are dealing with land.
With land and real estate in general.
Real estate, and there's some sort of movement that needs to take place. So
Yeah.
in South Australia, not at the moment, no.
Not at the moment. So I will mention, I think the only jurisdiction in Australia that requires registration of an enduring power of attorney is Tasmania. In all other states and territories, it's you only have to register with the Land Titles Office, or what it's called in South Australia, if you're transacting in real estate. Now, a very good follow-up question from Charlotte. Who can be an authorised witness for deeming not having capacity?
let me answer that in two parts. The authorized witness under the legislation to witness the signature of a donor on an enduring power of attorney are generally justice of the peace or a commissioner for taking affidavits, which are lawyers, and used to be an opportunity for certain police officers with certain qualifications to also witness that. But predominantly in South Australia, people would go to either to a GP or to a lawyer to have these documents witnessed.
Right. Now, there are a number of things I want to circle back, but Tony has asked an interesting question. How far away is the new proposed federal power of attorney that covers all of Australia? So this is the idea I think Tony's talking about, harmonization, which is often talked about. I think the attorneys general, it is definitely on the table, and there are advocates around the country who are trying to get some momentum behind this. I guess we don't know, you don't know, Tara, but it is something that is being discussed by attorneys general, and we do hope that in the not too distant future there is some movement there, because it does create some practical issues, doesn't it, for people?
Oh, absolutely. Absolutely. Particularly because we're now a society that moves.
Yes.
So we move state, and having consistent laws in each state would be very helpful.
Very helpful. Yes. Yes. So we hope, Tony, that does, we get news on that sometime in the near future. Now, I wanted to go back to the idea of creating an enduring power of attorney. How do you go about creating it? Is there a form in South Australia? And how do you get access to it? And does it cost money? And should you get independent legal advice? What are your thoughts on all of that?
Okay. So, yes, generally there is a form that one can access either through Services SA, you can buy the form, or you can download it from Land Services website.
I will say it's also on Compass as well.
Oh, there you go. When people prepare an enduring power of attorney through their lawyer, most law firms will have their own template and pro forma that they populate to reflect what is required under the legislation. So how to do it is you get the form, you populate the form, you must have it signed before an authorised witness. So that's sort of the process in Australia.
Yeah. Now, I've got a question too that I'm going to put to you, and then we'll follow up with a question from Ellen. When you create your enduring power of attorney, can you stipulate when it is going to be activated? Can you choose a specific time when you hit 65, for instance, or does it only kick in once you have a diagnosis of no capacity?
So the South Australian form that we have, there's two events, potential events of activation that people can choose from. One is that it is effective from the date of signing.
Right.
The other one is that it's activated in the event of incapacity.
Incapacity, right.
So they're the two sort of trigger points that people can choose in South Australia, and that's how the form is currently structured.
Right. And in South Australia, you can have more than one attorney, but is there a limit to how many attorneys you can appoint?
Technically, no.
Right.
But it is prudent advice suggests that you would like to make this workable and practical.
Yeah.
One of the things that I think is not always fully understood is that an attorney appointed under an enduring power of attorney document is a legal role with legal responsibilities and legal consequences if it's not done right. And so when I advise clients when they're looking at populating an enduring power of attorney, I tend to say to them, use this and not your heart, because the execution of an enduring power of attorney is not meant to be a reflection of your affection. So some clients will say to me, Tara, I've got 6 children, I'm going to appoint all 6 children.
Yeah, right.
That shouldn't be the thinking. You need to understand what the role is and what the job is and who is competent to do the job. It's really what should be the thought process in your
Hmm.
head when you're thinking about creating one.
Okay, great. Now, Alan asks, what are an attorney's roles when the adult, who we'll call the principal, still has capacity, but is being financially exploited and is willing to allow it? So, if attorneys are aware that abuse is taking place, what are the options available to them?
So the attorney perpetrating the abuse or somebody else?
Well,
And
it looks like it could be somebody else. Let's say it's somebody else, or it's one of the attorneys.
so let's deal with the one that I think most people get themselves very concerned about. If the appointed person,
Somebody else, Ellen has said.
oh,
Yes.
it's somebody else. So
Yes.
if somebody else is doing this, so we've got a number of issues we need to unpack here. If the donor or the person appointing has legal capacity,
Hmm.
really they're the key person that needs to be having a
Raising the
conversation with you
alarm.
and raising the alarm and taking steps to address that. Because at the end of the day, the attorney only really kicks in when normally when they no longer have capacity. The attorney can give them some advice and raise some concerns. Hey, you know, Joe Blogg is doing this. It's a little bit of a concern, don't you think? And discuss with them options. But when the person, we need to understand that when the person still has legal capacity, they should be the key person we're speaking to and making sure that we get directions from them as to what step they want to take to address it.
Yeah. And look, without knowing too much about the situation, Ellen, there can be, as we know from the research that was done through the prevalence study here in Australia on elder abuse just a few years ago, um, financial abuse can be committed by people very close to an adult. They can be, adult children, partners, and there can be a level of shame and reluctance sometimes to take action. It's one of the things we hope with compass.info is that people can access information and inform themselves about ways they might want to respond. Now, if you know of anybody that is being abused in any way, shape, or form, and you want them to take action or yourself, you can go to Compass. In our service directory, we have elder abuse specialists as one of the filters, and there's also the National Elder Abuse Helpline on 1800 353 374. Now, in South Australia, Tara, there's also the Adult Safeguarding Unit, which is a really, incredible service. Not every state has such a service available to them. So I would also recommend that. And of course, the organisation that you're from, Aged Rights
Advocacy service.
Advocacy Service. So there are definitely options there. Now, I wanted to ask a question here of Sue. I understood that the Advanced Care Directive was for the end of life decisions, not normal life decisions, e.g., deciding to put a person into a nursing home. Isn't the POA for decision making, lifestyle, health, etc.?
No,
Not in South Australia.
not in South Australia.
Do
So
you have an enduring guardian in South Australia, a document?
we used to, and
Right.
if anyone had executed one of those prior to the Advanced Care Directive Act
Taking over.
being, it's
Yeah.
still lawfully recognised, but
Right.
it's understood under the Advanced Care Directive Act. So let me just go back to that question. No, an Advanced Care Directive appoints a person to make accommodation, health and lifestyle decision, not at end of life. It's sort of everyday life. Once if Tara loses capacity, my substitute decision makers appointed under an Advanced Care Directive can make decisions about my accommodation, health and lifestyle straight away, not just because I'm in palliative care at
Right.
end of life. What the difference is that the Advanced Care Directive in South Australia has a provision within it, what we call the binding nomination component, where I can articulate my end of life instruction.
Right. Okay.
That's just a part of the totality of the document.
Okay. Very interesting. Thank you for that. Melissa asks, Tara, do you agree that a consumer with an authorized advanced care directive and an enduring power of attorney who has been deemed to have legal incapacity should not also require SCAT orders, guardianship administration, for them to be placed in permanent aged care if the consumer is unwilling? That sounds like a very specific case, which might be very difficult for you to answer, but
No, I do understand the
yep,
question,
yep,
and let me put that into context. I'm making
yep.
some assumption based on that question. If a person had planned ahead and appointed an enduring power of attorney, appointed a subject decision maker
Mhm.
under an advanced care directive, in the most part, there wouldn't be any need for tribunal orders. So SACAT is our South Australian Civil and Administrative Tribunal.
Yes.
So they should be able to function and be utilized as intended. And that's the point of the exercise, why you do this document.
Hmm.
Where SACAT may become involved, despite the fact that you've got an attorney appointed and a substitute decision maker, is that if there was a need for what we call in our state restrictive practices order, what we call Section 32 powers orders, an appointed substitute decision maker doesn't have that authority. You have
Right.
to get the tribunal to appoint a guardian, and then the guardian will then apply for Section 32 powers. That's why, in certain circumstances, despite you've already appointed someone, you have to go to the tribunal. Now, the tribunal may appoint the very same persons you've
Yes.
appointed as your subject decision maker. It's a pathway to get those restrictive practices. And why do you need them? It may well be that you decide Tara needs to move into a nursing home for her safety, but Tara's refusing to go and she's kicking and screaming. Well, you can't just forcibly take Tara to a nursing home without appropriate authority, because that would be a criminal offense. You need
Yes.
authority to do that. So
Yep.
that's why in some circumstances people might find themselves in that situation.
Great. Thank you very much, Tara. That was a great answer. Now, before we go to Josephine, I wanted to ask you one or two follow-up questions. One was, I think Ellen touched on the idea of abuse being, taking place if somebody has lost capacity and the attorneys are perpetrating abuse. What can be done to remedy that situation?
So in South Australia, well, let's go back to South Australia. There's a couple of pathways. One pathway is, and it's the cheapest and most efficient pathways. You make an application to the South Australian Civil and Administrative Tribunal for an administration order.
Right.
An administrator, once appointed, has the ability to revoke the enduring power of attorney. So it puts a stop to the mismanagement, the financial mismanagement by the people appointed. So,
Mhm.
and an administrator appointed by the tribunal has very, very similar legal responsibility as an attorney, as an enduring
Yep.
power of attorney. So that is the pathway, one pathway in South Australia. The other pathways, because under our legislation, is that people can make an application to the Supreme Court. And the Supreme Court could vary and revoke an appointing document if that is what the application is. But obviously that pathway is far more formal, far more
Expensive.
costly, and
Yeah.
you may well need a lawyer to help you go
Yeah.
down
Yeah.
that path. But
Yeah.
that's what's available in South Australia.
Right. Thank you. Now, obviously, becoming an attorney for somebody under an enduring power of attorney is a very important role. It's a legal role, as you've mentioned, with legal responsibilities. It doesn't come with any formal training. However, there are guides available. And actually, there's a brand new article on Compass called How to Be a Good Attorney. And you'll find other articles about how to choose an attorney. So, in South Australia, are there any other resources available to people that they could give to their, prospective attorneys to say, hey, read this so that you understand what this role is about? Because, it's a serious role and it could end up, being a role that some people have to perform for a long time.
Yes. Well, what I can tell you is the Aged Rights Advocacy Service, because we've got an elder abuse program, over the years we've created fact sheets and pamphlets. And some of those fact sheets includes things like what are the duties and responsibilities of an enduring power of attorney, and what are the duties and responsibilities as a substitute decision maker. So we've tried to create user-friendly documentation in language that's not legalistic, and people can understand that.
Yeah.
So we've got those. We also have the Legal Services Commission of South Australia has a law handbook online, and they do have some information on that website about enduring power of attorneys that may be useful.
Yeah.
So, and there's a lot around, I believe, even the public trustee, I think, from memory, may have some fact sheets that may be of some use.
Yes, yes. Now, you can probably also find all of these assets on the Compass website. There are over 1,000 resources from the public trustees all around the country, the Aged Rights Advocacy Service, and more. And there's specifically helpful advice about how to choose an attorney, who makes a good attorney, which is my next question to you. Who makes a good attorney?
Right.
Who is someone that you possibly should think twice about appointing as an attorney?
When clients ask me this question, I ask them to go back to what the role is and what the intention is. So it's somebody stepping into your shoes, making financial decisions on your behalf when you're not able to make it yourself. So let's break that down. You need someone who's got the time to do it. So when they step in, they got to understand what your finances are. They got to understand what the bills are, what your assets are, what needs to be done. So they need time. They need the ability to do that. They need the ability to I need to find out exactly what's going on. And they need the willing, because it can be time, resource, and it needs to be the word that I tend to use with my client. You need someone competent.
Yeah.
And so, for example, I would say to a client, don't appoint someone that can't manage their own money.
Yes.
If you know them well and you go, well, actually, they're always in debt.
Yeah.
It should be a red flag to you saying, well, should I really give them the keys to my bank vault?
Yeah. Yeah.
Not managing themselves. So it's about competency. It's about willingness. It's about having the time. So if you appoint someone who's incredibly busy, who is running around working 24/7, and you're imposing yet another responsibility on top of that, are they the most ideal person to appoint?
Yeah. Yeah. Now, I guess you should also, and we'll get into this because I do want to talk at length about supported decision making, but somebody who knows you well and who knows the decisions that you would want to make, because they're not making decisions based on their own values and preferences, and they're making decisions on your behalf. So I guess someone who knows you very well as well. Now, I wanted at this point just to highlight one of the reasons why our series is called You Decide, Who Decides, is that there's a very helpful new edition of this national guide that has just been published by the Australian Guardianship and Administration Council that is available on Compass. You can link from a big banner on our homepage, and this booklet is a really accessible guide to making an enduring power of attorney. And it lists lots of things such as, think twice about appointing somebody as an attorney if they might have any addiction issues, gambling or financial addiction or substance abuse issues. Another factor to consider is, do they live locally? A lot of people might appoint adult children. They could move overseas. That might work for you, but also being local is possibly a very handy attribute as well. So there's lots of helpful information on that guide, and it comes along with two very short and helpful videos, which are on the page as well. Now, A question here from Josephine. I'm in South Australia. I have added my son as an additional power of attorney. My bank made my daughter open a bank account as she is the attorney, I guess. I have spoken to the bank about adding my son as an additional attorney. They told me that he has to open a bank account as well. He's not happy with that. Do you know if he definitely needs to open a bank account? I haven't heard that question before, that an attorney has to open an account with the bank that the principal has their money.
Yeah, no, I agree with you, Brett. I haven't heard that before, but it somehow doesn't surprise me.
Right.
The thing, so I want to go back to an earlier comment that I have. Sometimes we're dealing with third parties and
Yeah.
we're having to adhere to what their requirements and criteria are in order to apply an
Yeah.
appointment document. Now, some banks will ask you to jump through 1,000 hoops before they would recognize and respect an appointing document. That shouldn't be the case, but it just happens. And there are currently conversations being had at the financial level to try and address that. The opening of the account is curious. I'm speculating at this stage because, as I said, I haven't really come across this before, but it may well be the bank's attempt to, I guess, understand how they interact and what dealings, financial dealings and interactions.
A little bit of oversight, maybe.
Yes. So
Yeah.
that's my suspicion, is the intention here, because they want to do that. Plus, they want to get new customers. I don't know. That's the cynical side of this. But
Yeah.
I suspect it's
There could be a benevolent reason for this.
yes.
Yes.
Wanting to see, I need to see have an opportunity to double check that you perform your duties appropriately.
Yeah, and it should be. We should mention that the banks in Australia are increasingly adding measures to monitor behaviours so that they can detect financial abuse. And so we don't know in this case if that's one of the reasons, but there are sophisticated technologies employed as well. Now, we've got a quick question here from Charlotte. Do you recommend the kits you buy at the post office for creating an enduring power of attorney?
Yes. The kit, if you're talking about the kit with quite clear instructions on what it's about, how to populate it, examples of how to fully populate a form, don't have a problem with that. There are some kits that's quite minimalist and not South Australian based, so be very careful with those documents because the form itself may not in fact be covering all of the fields that it needs to cover. But even with the kits, what I'd really like to press upon people is that people need to respect what this document is about and get some free legal advice as well. So community legal centers, legal services commission, you can tap into getting some advice about it, because depending on your circumstances, there may be things you need to think about when you are executing a document like this.
Yeah, you need some support. Now, one of the things that I just wanted to touch on before taking a few more questions is this document can be around for a very long time. But things change, people's relationships change, their circumstances change in many ways. How often do you reckon would you advise people to review their enduring power of attorney?
I advise my clients to review their enduring power of attorney every time the circumstance change.
Right.
And that could be quite minuscule. You could move house, you could move state, you can move overseas. So, for example, I may have chosen to appoint my best friend here in South Australia to be my attorney. I moved to Victoria. I now need to assess whether that's still practical as an option. And you might find yourself, you were married, then you were divorced, then you've remarried. All of those things might be very relevant consideration about the document that you've executed, and your finances may have changed as well. So there are additional. So one of the things that is underutilized in South Australia. When you populate the form, there is about a page and a half that people, it says under conditions that people don't use.
Right. These
Where
are instructions or limitations people
instructions
put in.
and guidance that's important to you and
Yeah.
how your finances need to be managed, but often that's left blank. And so, depending on your estate and how complex it might be, you might wish to utilize that part so that you're giving instructions. And one of the ones that I suggest, so no one oversees the conduct of an enduring power of attorney. There's no sort of government body that
Right.
that whoever you appointed is doing the right thing. So what you are able to do is inbuilt certain checks and balances within the document.
Right.
And the condition section is one of those things. So, for example, you may have chosen to appoint your son who lives in South Australia with you because that's practical, he's sensible, he's competent. But with the big ticket items, such as selling your house or major withdrawals of assets, you might put in the condition that if the house needed to be sold, the son needs to consult the sister who lives in Sydney.
Yeah, right.
And so you've injected some sort of overseeing component to this.
Right. Yeah. Now, I guess there's a logical next question to that, which is you could actually appoint your attorneys to make decisions jointly, couldn't you, where they have to agree on making decisions. And then I think then in that scenario, you probably wouldn't want too many because it gets complicated to do that.
And not workable.
And just not workable. But you can, I didn't realize you could put in instructions as the one you just mentioned. I did want to also highlight that in You Decide Who Decides, the guide, they've also suggested you may even appoint your accountant to do an audit of your accounts on an annual basis to support your attorney. Of course, that would involve additional fees that you would have to incur. Now, taking on the role of an attorney is an unpaid role.
Yes.
And so that is very important to stipulate because there really can't be any, or shouldn't be, I should say, any conflicts of interest associated with the document unless they're explicitly acknowledged. But if you wanted to pay your attorney, could you?
Yes, you can. So there's two groups. You are able to appoint professionals to be your attorney. And so often that's lawyers, accountants, public trustee companies. And if you appoint them because you've got no one else that you think is appropriate around you to appoint, you can, but they will charge for their services, and that needs to be taken into account. If you appoint what we call lay people, so your family members, friends, neighbors, what have you, it is an unpaid role, but you are again able to put in the conditions some provisions for that.
Right.
I've certainly seen that in the past, but you need to identify what that is. It needs to be quite transparent because one of the other things that is critical in this jurisdiction so that it minimizes conflict and angst is the conversation people should have before you do it, after you've done it, so that if there are any questions, the person appointing is able to answer all of those questions. And so if you decide that you're going to appoint your best friend, but she can pay herself X dollars a week, and that's in the document, let people know so that if it sort of comes to light, they don't start suspecting the friend doing the wrong thing. And you made that choice.
Yes.
Made that decision.
Yeah. Now, Tony makes a point here, which I think we'll just quickly acknowledge. I have always kept a separate financial record as an attorney, and that is absolutely diligent and that is perfect behavior. And you are right, that is actually a legal requirement as an attorney to keep money and receipts and everything like that separate. Now, we've got a question here from Alan. I helped an older person challenge how the Advanced Care Directive and Enduring Power of Attorney were being managed by taking the case to SACAT. The biggest issue was the squirreling away of a large amount of money in a long-term deposit, and the older person was therefore deprived of its use and benefit. SACAT simply ruled that as the EPOA and AC Advanced Care Directive were validly executed, there was no case to answer. Where to from now? For now, um, yeah, that's an interesting one.
It is. Okay.
It's
We've
a
got to,
particular case, and we can't really respond to individual cases. Um, but what
however,
what
it-
options would be available?
yeah, I think what needs to be understood is this. So, as our title suggests, you decide who decides. These documents, Enduring Power of Attorney Advanced Care Directive, is a means by which people, every adult, is able to decide who decides for us. And so a tribunal would be reluctant to disturb me exercising my right, deciding who it is that makes decisions for me. So
Mm,
I'm just picking up that arm of that question. So I am not surprised that the tribunal responded in that way. However, this is the big but. If the behavior and the activities of the appointed enduring power of attorney is bordering on negligence,
hmm.
and the evidence you are presenting to the tribunal is that, then it might be an entirely different response that you will get from the tribunal. In this particular case, it sounds like the appointed attorney is squirreling away money for a rainy day, and unless there's a harm that is able to be identified, except that, oh, well, mum now can't access thousands of dollars,
Mm.
but she may not need it right now. The tribunal may not have enough before it to be persuaded to disturb the right that I have to choose who I want to decide for me.
Yeah, right. Okay. Thank you. Now, before I take another question, I did want to, before time slips away, talk about the importance, the central importance of supported decision making in the relationships that attorneys have with principals. One of the things that, is sort of self-evident, I guess, is that an enduring power of attorney has the word power in it. It has a lot of power that comes with that document. But attorneys are required under law, if not in legislation in South Australia, increasingly through the courts to support principals in helping them make their own decisions right through the process. So the supported decision making is fundamental, isn't it? You're making decisions on behalf of the principal and you need to support them, even if their capacity slips away.
Okay, I need to answer that in this way. I'm so sorry, Brett, but the supported decision making is actually very, very different to an enduring power of attorney. So,
Yep.
an enduring power of attorney, it sits in the domain of substitute decision making. So that person steps into the shoes of the appointor and make decisions on their behalf. The supported decision making principle is a paradigm shift from that, where we're
Hmm.
supporting the person to make their own decision for as long as possible.
Yes.
And in fact, when you reach the line, when you're supporting a person and you reach the line that they can't make their own decision, that's when the enduring power of attorney kicks in. So they don't sort of work at the same time, they work in stages of each other.
Right.
However, the point that I think you're making is that what is now an increasing push by the community is that these documents should be exercised respecting the will and preferences of the
Yeah.
appointor. That to
Yeah.
the extent that is possible, they will make decision consistent with the decision the person would have made had they been the one making the decision themselves. And that's talking about the relationship you mentioned earlier, that you know the person and you will do what they would have done. So that's what
Yes.
we're talking about. So we're sort of, that's about will and preferences. Supported decision making is about them making their own decision. Enduring power of attorney is another person making a decision on their behalf. And what is the problem at the moment? And the challenge, not a problem, the challenge we have in South Australia is that our legislation is 40 years old and it's
Yes.
no longer fit for purpose. And those principles are not embedded in our current legislation. And
Yes.
our current legislation is working on best practice. best interest, I beg your pardon, best interest principle. So appointed attorneys will make financial decisions on behalf of their appointor based on what that person thinks is in their best financial interest. Whether that aligns with wills and preferences depends. Whether that aligns with supported decision-making principles depends. It's a very tricky jurisdiction to get into.
Yeah, a very interesting one. And Compass has two very good articles on supported decision making. And so I highly recommend they are available in the Enduring Powers of Attorney section and in the Future Planning section and in the Enduring Guardianship section. Now, one quick question before we go to Raylene. How do you revoke an enduring power of attorney in South Australia? And what's
We
the
have a
process?
revocation form that
Yep.
people populate.
Mhm.
So that's one way. Technically, you could revoke it. So I don't want to direct people the wrong way, but the appointor could tear up the original document and any other copy, because you actually need the document as evidence and proof that you are the appointed person. That's one way. You could also do a letter. The revocation form is just a lot more reliable and more recognizable, because remember, you're dealing with third parties. If I revoke an enduring power of attorney, I need to show that to a bank to say, do not deal with Brett anymore. I've revoked Brett as my attorney. So
Yeah.
there is a form in South Australia that people can execute and prepare so that
Right. And you can access that form in the South Australian section of our Enduring Powers of Attorney section on compass.info. Now, the question we've got from Raylene is, with an enduring power of attorney, can you have your partner as the main donee? And then should he not be able to, can you appoint your son and two eldest grandchildren jointly and severally to be attorneys? So I guess this is the idea that you've got some appointed attorneys, and then you might also appoint some substitute attorneys to kick in at a certain, if that original attorney is not able anymore to fulfill that role.
So, Raylene, the answer to your question is yes. In circumstances like this, if this is what you'd like to achieve, it may be prudent to seek the assistance of a lawyer to help you with that. So this is what we call alternative appointments.
Right.
So the way it would normally look is I appoint my husband to be my attorney, but if he's no longer able or willing to be my attorney, then in that event, I appoint whoever that I might appoint. And there are actually ways that you can manage the appointment if you have more than one. So say, for example, I appoint 3 people to be my attorney. If there was a disagreement between all 3, then the majority rules.
Mm-hmm.
So there are those variations that lawyers know. And so one of the benefits of getting a lawyer to assist you in preparing and executing an enduring power of attorney is those nuances. If your circumstances and your needs require some of those elements, it's hard to do that in a will kit because you may not know how to articulate that, how to set that up so that it is understood and lawfully recognized.
A good reason to seek independent legal advice. Now, we're almost up. We've had a fantastic hour-long conversation, and thank you very much for all your questions. If anyone wants to put another question to Tara, put it into the chat now, because I'll be soon wrapping up today's conversation. I have 2 more questions just to ask you. One is a follow-on from Raylene's question. Often people do appoint their partners or their best friends as their attorney. And I guess the reality of those appointments means you're possibly appointing people your own age often, and the chances of you losing capacity might be equal to them losing capacity. Is there some advantage in choosing someone much younger than you?
Yes, except for the reasons that you've raised. However, there is reason to appoint a partner, and then, like Rylene's question, you appoint your partner and then your children as substitute decision makers, because imagine a situation where I may have appointed my adult children to be my attorney. I lose capacity, and suddenly they're making financial decisions for me, but my husband's left in the dark.
Yes.
He's kind of put aside at the corner, and they have to sort of consult the children with respect to any joint expenses, joint bills, and that may be very tricky depending on the family structure. So the scenario that Raylene mentioned is really more the ideal scenario, that you might appoint your partner, but if they're not able to anymore, then the adult children.
Got some backups.
Yes.
Yeah, yeah. You've got the B team. And who can kick in. Now, my last question to you is, sort of circling back to something we talked about at the beginning, which was that the laws around enduring powers of attorney in Australia vary from state to state and territory. Say you created your enduring power of attorney in Queensland and then subsequently moved to Adelaide, but now you live permanently in Adelaide. Should you get a new one made up in South Australia? Or can you just rely on the one you created back in Queensland?
In theory, you can rely on the one that you made in Queensland. So what has happened a few years back, all of the state government entered into an agreement respecting each other's appointing documents. So that in theory, the document lawfully executed in Queensland, and they moved to South Australia, should be legally recognised by us to the extent that it is consistent with that state laws. Right. And so I think you might need to correct me, Brett. Was it Queensland where it's financial and lifestyle health?
It is, yes.
So we would recognise that in South Australia only to the extent of the financial.
Yes, not the health
all the other bit, because that's inconsistent with our laws.
Yeah.
So
it's a good example in a way then, because if you did want to can have your health and lifestyle decisions taken care of, you're going to need an advanced care directive in South Australia. So it is important to consider those things. And as you say, people do move around. And so best to be very across the laws that apply.
And let's go back to the earlier conversation we had about reviewing. That's a change of circumstance.
Yes.
Compel you to review the document.
Yes.
It's less about the legality of things. You don't want to be bloody minded about this, but you might actually go, the people I've appointed perhaps is no longer the suitable ones because I'm now in South Australia.
Yeah, yeah. So I think I'll wrap it up there. Tara, thank you so much for your expertise and experience. It's been a great hour. Thank you to everybody that put all those very interesting and challenging questions to us. We will be sending out an email tomorrow with a link to the recording of our conversation today, along with links to the You Decide Who Decides guide, videos, and a lot of the sections that we've been talking about today. And you'll be able to find those as well on the Compass website. Now, as I mentioned earlier, Compass is a project of Elder Abuse Action Australia to make information about topics like enduring powers of attorney accessible, and for you to be able to find services to support your needs. And you can get all of that at compass.info. So thank you very much for your time this afternoon, and enjoy the rest of your day.